My name's Murray Trachtenberg. I'm a lawyer. I'm general counsel to the Manitoba Métis Federation. And I'm aware that the amount of time allotted is being somewhat constrained, so I'm not going to go through the whole presentation that I had, but I'll try and highlight some main points. I want to just comment, though, and build on something that Al just talked about, the whole concept of inherent rights, contingent rights. There's another concept when we're talking about self-government, that's the concept of sovereignty. And for the last 20, 30 years, governments, courts, Indigenous people have been struggling with the relationship in all of that. And what I want to do this morning is I want to zero in on the inherent rights of self-determination and self-government. I want to talk a little bit about what Canada says. I want to look at the 3 agreements that have been signed. And let me just pause. I'm not here to criticize anybody. The contents of those agreements are negotiated by capable counsel. Political decisions were made as to whether or not those agreements had enough and whether they should be signed. You've heard Al said from the MMF's point of view, they did not go far enough. They did not provide what the MMF, as instructed by the grassroots and based on the legal positions it's taking, so it didn't sign. And I'll walk you through a little bit of how I see the signed agreements working. And one of the reasons I want to do that is because it reflects the position that Canada has taken, at least up to now, when it comes to Métis self-government. So let's talk firstly just about the inherent right to self-government. So back in 1995, Canada launched a paper called the Inherent Right Policy, which provided guidance on self-government negotiations with Indigenous communities. And that policy has been updated, changed different times. So I looked at the version in September of 2010 called The Government of Canada's Approach to Implementation of the Inherent Right and the Negotiation of Aboriginal Self-Government. And I've stopped there. Implementation, because it's one thing to say Indigenous people have an inherent right to self-determination and self-government. You heard Al refer to UNDRIP, which also says it, but it's the implementation. How are you going to get there? How do you exercise it? That has been the area of conflict and disagreement. But anyways, back in this policy, Canada said things like, the Government of Canada recognizes the inherent right of self-government as an existing Aboriginal right under Section 35 of the Constitution Act 1982. Couldn't be clearer. If you go to the website right now of Crown Indigenous Relations and Northern Affairs, under self-government, same wording. Canada recognizes that Indigenous peoples have an inherent right of self-government guaranteed in Section 35 of the Constitution Act 1982. And back in 2018, the Department of Justice published a document called Principles Respecting the Government of Canada's Relationship with Indigenous People. So there's a number of 10 principles. The number 1 principle says, the Government of Canada recognizes that all relations with Indigenous peoples need to be based on the recognition and implementation of their right to self-determination, including the inherent right of self-government. And it goes on to say how this right is grounded in Section 35 of the Constitution Act, Articles 3 and 4 of UNDRIP, which Al just referred to. It talks about the mutual responsibility of all governments to shift their relationships and arrangements with Indigenous people so that they are based on recognition and respect for the right to self-determination, including the inherent right to self-government for Indigenous nations. And there's more, and it goes on. So what I'm suggesting to you is there's no issue whether Canada recognizes that the Métis Nation has an inherent right of self-government that's protected by sections 25 and 35 of the Constitution Act 1982. Of course it does. It's been saying as much in its official documents for years, and it continues to say that. The real issue when you talk about self-government, the implementation of self-government, is firstly, what's the nature and scope and content of the inherent right? What is it? How wide is it? What does it allow Indigenous peoples to do? Then the next question is, who can implement it? How do they get to actually use it? And for the Métis, who has the right to implement it? And then there's another part. When? When can you implement it? Now, I'll tell you the MMF's legal position, and it's a legal position I think lots of Indigenous peoples share. The MMF says the Manitoba Métis community has an inherent right to self-determination, self-government, which includes the right to determine its internal governance, its own structures. And that right is recognized, affirmed, protected by sections 25 and 35 of the Constitution Act. Sounds very much what the Government of Canada has been saying for many years. The MMF also says that the Manitoba Métis community's inherent right of self-determination and self-government exist as a matter of law. They don't depend on Canada recognizing such rights in an agreement. And you heard Al talk about contingent rights, inherent rights. If it's an inherent right, it's there. You have it by virtue of being an Indigenous people under Section 35 of the Constitution. And the inherent right to self-determination and self-government doesn't depend on the Parliament of Canada passing legislation saying you have it. That's a legal principle, and it conflicts with Canada's legal position of sovereignty, that in Canada there is one sovereign government. There's not going to be a bunch of different Indigenous sovereign governments. This is part of the tension and the fight. And the MMF also takes the position that the MMF, even though it's incorporated under provincial legislation for companies, which is something that had to take place years ago because the government wouldn't talk to you, banks wouldn't talk to you, and this is commonplace right across the Métis homeland. No one would give you money or deal with you unless they recognized you. And if you said to them, we're an Indigenous government, an Aboriginal people who, and this is our self-government, they had no idea what you were talking about. So you're incorporated, but the fact that the MMF is incorporated does not prevent it from being the government of the Manitoba Métis community right now, and doesn't prevent it from exercising the inherent right of self-government. And when we talk about implementation or exercising inherent right, well, that involves the jurisdiction to look after your internal affairs, and jurisdiction means the ability to make your own laws. And that's what we're talking about here, and that is the whole issue when it comes to this inherent right. Sure, you have it, but who exercises it? When do you exercise it? How do you exercise it? And who's going to tell you? Now, if you look at the agreements that have been signed to date, you see Canada's position. And the first thing you should notice is that those agreements, called the Métis Government Recognition and Self-Government Agreements, and that's what they are. That's what they're called. They have, and I'll use the word deferral. because that's the concept. The deferral, meaning down the road, you're going to have a Métis government. And I said to you, from the MMF's point of view, it is the Métis government for the Manitoba Métis community. So we already have a tension here and a difference of view and a difference of opinion. But the agreements that have been signed do not recognize the current Métis governing members as an existing Métis government. And they don't provide for the current members to have current jurisdiction to exercise that inherent right of self-determination and self-government. So what they do is they require a number of things to take place before the Métis can exercise the lawmaking jurisdiction that inherent right of self-government entails. And once those things have taken place, and I'll walk you through them briefly in a few moments, once they've taken place, Canada's position is that you then need an act of Parliament to authorize and recognize that jurisdiction. And then you have a Métis government that has lawmaking authority that is recognized and enforceable and constitutionally protected. Now, the current agreements work like this. There's Section 3, where Canada recognizes that there's a Métis inherent right of self-government. And the agreements are interesting because they say in 3 that this recognition is immediate upon the signing, which sounds good, and I'm pleased to see that. It says the Métis Nation within whatever province has the inherent right to self-government over its internal governance protected by Sections 25 and 35 of the Constitution Act. And then when you look at what the definition of the Métis Nation within the province is, they're really talking about your existing citizens or members. And they're saying, yes, we recognize you have an inherent right. Okay. And we say the minute we sign it, we're recognizing it. But the problem is in Section 3.02, which nobody really talks about, but you find that throughout all the agreements, because 302 says this: for greater certainty, Canada's recognition of the Métis Nation within whatever province, right of self-government will only be in accordance with the terms of this agreement. So yes, I recognize it, but it's conditional. I recognize it in accordance with the other terms of this agreement that you have. So then let's talk a little bit about some of those other terms. Well, I said at one point, the Government of Canada will bring forth legislation. It's referred to as federal recognition legislation. And that legislation will be passed by the House. And the parties, being the Métis government involved in Canada, are going to set what's called the implementation date, the self-government implementation date. They'll pick a date that after the legislation, boom, everything is in place. But before you get that act, according to these agreements, you have to do a number of things. And this ties back in with some of the stuff that Al talked about. And you find these criteria for self-government implementation. Chapter 5 of the agreements are called requirements. And it says, the following requirements must be met in order for the Métis government and the jurisdiction, and the jurisdiction they're talking about is internal governance, your inherent right. Before it's recognized, you're going to have to do a number of things. I'll read out some of them. A constitution has to be ratified. This agreement has to be ratified by the Métis citizens. You have to sign an intergovernmental relations agreement with Canada. You have to co-develop, mutually agree, and sign a fiscal financing agreement, which will provide funding to the Métis government. And the parties have to develop and mutually agree to what's called the transition plan. And that transition plan is to guide how you get out of corporate form into true government form. Because you can't be ultimately a true government, a level of government, and still be incorporated. You can keep your incorporation for certain things, and that may be part of the plan. But all of these steps have to take place. And it's then and only then that the legislation gets passed, and then Cabinet, through an order in Council, will set the self-government implementation date, and then you have it all. And this whole scenario that I'm telling you is confirmed when you start to look at the definition of terms in the agreement. So when you look at Métis government, you find it defined as this: the government contemplated under this agreement and established by the Constitution as the successor to MNO, MNS, MNA, and recognized by the federal recognition legislation. So when you read the agreement and you see the term Métis government, Métis government, Métis government, just remember, Métis government means what I just said. You're going to go through all the steps. You're going to have your legislation. And this is in keeping with the approach Canada has taken for other Indigenous people, that you need federal legislation, that you need legislation to make it constitutionally embedded, and to make your jurisdiction enforceable against other parties, including, they say, against Canada. So the transition plan, I'll just talk about that for a moment. It's going to, as Al said, contain a provision as to how you ratify. How do the citizens, because Canada isn't just going to deal with Métis government leadership. They're doing the same thing that they've done with First Nations, and they want somehow this agreement, once signed, to go back to the people and be ratified. And how you ratify that and who sets the terms, those are issues for negotiation. As I said, in these agreements so far, they've elected to go with a mutually developed and agreed to plan. That wasn't something that the MMF was very happy about. I think one could mutually try your best to negotiate in that, but at some point, if you are talking about the transition of the Métis for their inherent right of self-government, and you can't get that mutual development and recognition and agreement, someone has to make the decision. It's not going to be Canada. Otherwise, it's not an inherent right. In any way, I'll just conclude with this. When you look at clauses 901, 1001, 1101, these are the jurisdictions in the agreement that talk about citizenship, election of self-government representatives, internal structures, financial management, government institutions. All of those jurisdictions to make laws will be recognized for these Métis governments as of the self-government implementation date. And just to say it again, the self-government implementation date is the date everyone agrees that after the legislation, after all the requirements have been done, the parties agree this is the day, and on that day, when it's implemented, the Métis government, which is the successor, will be there. It will have that jurisdiction. All the laws it's supposed to make are supposed to be made ahead of time, and they'll be validated and ratified, and then you have your self-government. That's how this works. I said I wasn't here to criticize anyone. I was asked to come and explain it, and I hope I've clarified some of the terms. I'm going to turn it over to David Gray.